Hello and welcome to True Crime Daily's The Sidebar, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based here in Los Angeles and previously an LA County prosecutor for nearly a decade. We are recording this on Friday, July 29th, 2022. In this week's episode, we will be discussing the continued sentencing for Parkland shooter Nikolas Cruz, as well as the ongoing murder trial for the men accused of killing Kristen Smart and hiding her body over 25 years ago. And we'll take a quick look at news around the country, including the last two officers to be sentenced in the George Floyd's murder case, Brittney Griner's testimony in a Russian court, and pending lawsuits against two social media platforms for their effects on children. Today, we are excited to be joined by Dr. Tracy Pearson, a trial and appellate lawyer and investigator for almost 2 decades, as well as a child welfare specialist and legal analyst that you may have seen on any number of media outlets. Welcome, Dr. Pearson.
Hi, it's great to be here. Thank you for having me.
Absolutely. Before we get started, could you just tell us a little bit about your background and what your current practice is today?
Sure. I actually am not practicing law. I went back to school. I earned a doctorate in education, focused on organizational change and leadership with the idea that I would help people fix what was broken. My dissertation is on implicit bias in internal investigations. And so I've really focused on trying to improve the outcomes for people who have to experience those types of things. And it has a broad range of applicability in law enforcement and a number of different areas. And I have really been focused on trying to get out there and educate folks about the law and about a whole lot of different things, because I think more information is better.
Absolutely. Well, we love that we're having you on this week because we know that you have those insights. And so I'm sure everyone will love hearing your thoughts on these cases because they are fascinating in their own right. So first, let's turn to the sentencing hearing that's continuing in the Nikolas Cruz case, out of Broward County, Florida. Sentencing continues for Cruz after the 2018 Parkland, Florida shooting that left 17 dead and an additional 17 injured. Cruz pled guilty to 17 charges of murder and 17 charges of attempted murder in October of 2021, which is interesting because now all we're dealing with is the sentencing phase of the trial, not the actual guilt phase, and we'll get into that. This week, Broward County Sheriff Sergeant Raymond Beltran gave a vivid description of an attack he suffered at the hands of Cruz 9 months after the Parkland shooting while Cruz was in custody. After telling Cruz to walk properly, in the video you can see Cruz kind of pacing around. Apparently Beltran tells him to walk properly. Beltran then alleges that Cruz flashed him middle fingers at him before charging him, resulting in the pair wrestling on the ground. And the video is very shocking if you get a chance to see it. Cruz's online history also came under scrutiny when it was revealed that he did research on mass shootings for months before the Parkland shooting. Prosecutors also read comments by Cruz online in which he made multiple references to his desire to kill people, including comments such as, "I'm going to be a professional school shooter," and referred to himself as a psychopath. So obviously really disturbing and shocking evidence that was presented in that case. Dr. Pearson, typically in a trial, you would not hear evidence of the defendant's conduct that occurred after the crime. Can you explain to us why they're able to introduce that by the prosecution in this case now, and how does that play into the idea of the factors in aggravation?
Sure. Law School 101. Yeah. The state of Florida has this really elaborate statute that's been challenged over the years when it comes to capital crimes. And when you look at it, it's fascinating because there are 16 aggravating factors, only, I think, 8 mitigating factors that are articulated. So you can see where that's headed.
Right.
But where this comes into play is when you're talking about the various aggravating factors, like that he could create a risk of death to a great many persons, that he attacked a law enforcement officer, he was engaged in the commission of a felony. these are the types of things that they are pulling at. They're pulling at little threads to try to build I use visuals a lot, to build a little quilt here that will lay flat and allow them to get the verdict that they're looking for, which is the death penalty and not life in prison without parole, which would be if one juror disagreed with the death penalty. So that's what we're looking at. And for me, I see that incident a little bit differently in that, so why did it happen? This kid's sitting, in jail, and he's awaiting his final fate. Why did it happen? When you look at the transcript from the interrogating officer, you will see that from the original offense, so the original shooting, you will see someone who is, I think, fairly disturbed. Just never mind the incident itself. There's a number of things that happen in that transcript. But he is asking the sheriff who's interrogating him to kill him. Are you going to kill me? Will you kill me? Will you, And I think that he wants to die. I think that he was too cowardly, if you will, to die by cop, a suicide by cop during the shooting. And ultimately, he was trying to create a circumstance where he might get shot, where he might end up dying. And unfortunately for him, that didn't happen, I guess. And so now this is evidence that's being used in his trial.
Interesting. Yeah, I think it's important to understand that this phase of the trial is less about the crime, even though the crime is obviously taking a very important role in all of this, because it's important for the jurors to understand how heinous the crime was. But it's more about him as a person. And is this the type of person that we should levy the greatest kind of penalty that we have in this country, to take a person's life on him? And so it's important for the jurors to understand who he was completely, even outside of those crimes, including that, hey, he's even continuing to commit acts of violence while he's still in custody. In fact, this person may hurt someone else down the line, even if you just put him in prison. So that's important for them to understand. But you make an interesting point that I wasn't aware of. Perhaps, and to help me understand this could maybe even play into his defense if it shows that he's in fact suicidal. Is that right?
Yes. There's an interesting fact, though, when it comes to this case, and that is it appears, and I have to check it again because there's been a lot of filings in this case, obviously, but that his defense team has withdrawn the mitigating factor notice for, it looks like that it was committed by the defendant under the influence of extreme mental or emotional disturbance.
Interesting.
Which is strange, because when you look at the mitigating factors, what you're sort of left with is the age of the defendant, the evidence of any other factors in the defendant's background that would mitigate against the imposition of the death penalty, and that him having no significant history of prior criminal activity before this offense. It's strange to me. It seems illogical to me, because wherever you fall on the ideological spectrum, folks say guns kill people, not the other way around. And when you are looking at the other side of this, it's about mental health. People who are mentally ill, good people with guns are okay. Mentally ill people shouldn't have guns. But then what happens is somebody who is, frankly, you have to be mentally ill to do this, right? When you think about the details of this that we've heard in the trial, the things that were done to these kids and to these three adults, you have to be mentally ill. And so you're mentally ill. And so what are we going to do? We're going to give you the death penalty. We're going to ask to give you the death penalty because you're mentally ill, right? Not because you used a gun, but because you're mentally ill. And it's this paradox that just doesn't make any sense to me. And, my ideological spectrum is fairly liberal. I think that, you shouldn't kill people. I don't think the government should kill people either. And, for him to sit in prison for the rest of his life and suffer is frankly more deserving, because he didn't want to live based on that interrogation video and that transcript. And he was lonely. And there's a whole series of facts that you learn from that interrogation video. But this would be the most punishment that you could give this kid.
Interesting. Yeah, not to get so kind of into the weeds philosophically about the death penalty, but I think part of it too is it's a way for that community to send a message, right? It obviously isn't going to, I don't think it's going to repair anyone's wounds. They've lost loved ones. Nothing will ever bring that back. But I see it too as a way to send the message that this is the greatest type of crime that can be committed in our society. And so therefore we're bringing the greatest type of punishment. And again, we could go back and forth all day long on whether or not that brings any benefit at all. But it seems to me that this trial is very much about that. I mean, you had one of the most shocking acts of violence are by a citizen against other citizens that our country has seen. And it was, so devastating, and it created an entire movement that came out of it. And I guess this might be the period at the end of the sentence to say that we then bring this greatest penalty, or we're asking our community to then bring this greatest penalty against this person. But
and I totally agree with that. I think that more needs to be looked into when it comes to the weapons. The weapon, it's just for sake of conversation, is that bullet comes out of that barrel 4 times faster than a handgun. And it actually has a velocity faster than a jet can fly by feet per second. And so it is deadly. And I understand folks like guns and like to shoot, and I'm not begrudging anybody that. But do you have to use this thing?
Right.
And does that have to be widely available?
I'm actually glad that you bring that up, because so much of this talk about gun control, people get fixated on the weirdest things, and one of them is the caliber of the bullets. And they talk about, what do we need these different calibers? But as you point out, the caliber in the weapon that he used is actually low. It's similar to a .22 rifle, right? But the exit velocity from the muzzle is so high that that's why it causes such devastation and death. So I think it's important to at least educate ourselves about guns and what we're talking about, especially if we're going to get into discussions of gun control. But again, we're kind of in the weeds of where we started.
Do a whole show on that.
I know, absolutely. But one of the other interesting things that's come out recently in this case that I wanted to ask you about was his search history, and I'm curious to get your thoughts on: is this at all? I know why the prosecution's doing it, right? I mean, he's essentially got hero worship for mass shooters. I mean, he's looking up other mass shootings. He's looking for videos on it. He's researching the shooters themselves. He is searching for things like, how do you kill a person at 500 yards? It's obvious, the planning, the premeditation, the obsession with this stuff. Is there any way, though, that the defense has an argument or could use this search history to explain kind of his mental state and its deterioration?
Absolutely. They could try to harness that and spin it, flip it, and say that he had long-standing mental illness. It wasn't, an isolated, this is not the normal behavior of a normal person who's sitting there and researching this stuff, unless you happen to appear on shows like this, so that we can talk about it. But I think it is absolutely usable in that manner. And I also think that, I've been reading and hearing about folks taking issue with it. I do think because of monitoring people's search history and whatnot. Look, when you engage in a potential criminal act that hasn't been adjudicated yet, it's fair game. They're collecting evidence. And it's, if reasonable suspicion of crime occurred, you're gathering information to try to determine whether in fact it did occur, and what caused it, and how to prosecute it, and maybe even how to defend it. It's there. It's totally viable. I think the question that I have, and it's something that keeps coming up in my conversations with folks about this case, is that this prejudicial probative value. At what point are we appealing to the emotional piece of a juror's mind? versus, how does this establish some sort of aggravating factor that is objective? Because the jurors, when they go back to that room, they have to look at the evidence, and they have to match the evidence up with the aggravating factors. And the aggravating factors have to outweigh any mitigating factors. And it has to be objective. It can't be, that's how I personally feel, because you're not making a decision based on your feelings. If you were, then we wouldn't be doing this for 16 weeks. Right. So that's where my concern is how much of this. We saw early on there was a lot of scuffle over Nazi symbols, swastikas, and whether that was going to be admissible or not. And this judge, for whatever reason, is taking things piece by piece, and that's another whole conversation. Is this judge?
Yeah, I'm glad that you pointed that out too, because something I keep thinking about is sometimes the prosecutors get exactly what they ask for, and it may be, like you said, too much evidence that carries far more prejudicial weight than it does probative weight, and therefore they might be creating appellate issues for themselves, which is the last thing they want in this type of a trial, when the whole country and world is watching. Then to have this whole thing maybe reversed on appeal. And I was thinking, and the defense has been laying the groundwork for that every step of the way. They're making all the objections that they can to just lay that groundwork for appeal. And one of the pieces that stood out to me, to go with your point about, swastikas, what was the real probative value of that, was they played the videotape of him after the shooting ordering an icy, I think, at a sandwich shop in close proximity to where the shooting took place. And it was offered for no reason, and other than the prosecution said, well, it's important to understand where he went and how he was arrested. But really, we all know the point was to show how kind of cavalier this man was afterwards, and how he had just taken the lives of 17 people, and it was devastating. And he's composed enough to order an icy, and I think he even left a tip. And I thought, okay, well, you got that in, prosecution, but make sure this doesn't come around and bite you in the tail. Is that kind of the point that you're making as well?
Yes, because when you read the transcript from his interrogation, there's some suggestion in there that maybe he was disassociating at some point, that his brain shut down. He has a conversation with, there's two things that happened that struck me. He has a conversation with his brother, Zach, who I think we're going to hear from as part of the defense case. And just the nature of the conversation and the details that they talk about, it is if he isn't there. He isn't all there in his head. Just after that, I think it's after that, he finally agrees to eat something, because the sheriff keeps trying to get him to eat something. And so he offers him pretzels. And what happens is Cruz says to the sheriff, do you want some? And offers to share them with him. And to me, that was sort of like a jaw drop moment. I was like, wait a minute, you're sitting here in a room after you've killed 17 people, injured a bunch more, scared the bejesus out of many, many more than that, right? Caused all this terror. And you want to share pretzels with the guy who's interrogating you. Wow. There's something off there.
Yeah. Yeah. And so people listening or watching understand too, when we're talking about his mental state, there is no, the guilt phase is over. So he's not trying to do a not guilty by reason of insanity defense here, but it's just important for the jurors to understand his mental state, to understand if this person can be held accountable, right? Like, can they really be truly held accountable for their actions, i.e. putting them to death for their actions, because of kind of maybe this disassociation that he was experiencing or had been experiencing for some time leading up to this. Is that right?
Yes, that's right. What we're not looking at guilty mind. What we're looking at is, is there anything in his background, or is there anything in the facts and circumstances surrounding what happened that would lead, in essence, a juror to want to give this person some mercy, to give them not forgiveness, not benefit of the doubt. It's to give them some charity in this, that yeah, you did a really horrific, horrible, awful thing, but we're not going to take your life. We're just going to make you sit in a cell for the next however long you live. And it's the only reason, let's say, is because of there was just something wrong with the brain, the way your brain was operating that day. In other words, it wasn't clear-minded, intentional behavior that you had rationalized yourself, that wasn't impacted by other things.
Yeah.
Maybe.
Interesting. Well, it's a horrible case. It's a tragic event in our history, but it's also a fascinating trial to watch as it unfolds, and we'll continue to pay close attention to it. Let's turn to another case, now back on the West Coast, dealing with the Kristen Smart murder trial has been delayed for a second time in 2 weeks. The disappearance of the Cal Poly student Kristen Smart in 1996 shocked the local community. Her body was never found, but she was declared dead in 2002. Now Paul Flores faces first-degree murder charges, while his father, Ruben Flores, is charged as an accessory to the murder. Nearly 25 years after Smart's death, Paul and Ruben were arrested in 2021. Prosecutors allege that Paul Flores killed Smart in his dorm room before Ruben helped him hide the body. The ongoing murder trial has been paused again, however. This time the trial was delayed because a juror couldn't attend due to an unexpected emergency. And instead of seating an alternate, the judge opted to postpone the trial. The trial was also delayed on July 19th for health reasons. This is not the first odd circumstance to happen in the case. Both men are being tried at the same time, but with different juries. And the trial was moved after a judge had ruled that Paul and Ruben would not likely receive a fair trial in San Luis Obispo. Both of those really interesting moves, I think, by the judge and by the prosecution. But first, Dr. Pearson, I wanted to talk to you about these delays. I mean, obviously, they sometimes happen in trials. Seems like they're happening a lot in this case. A lot of people are watching this case. Do you think it could affect the rhythm of the case for the prosecution, and how important is that?
I think that it could affect the rhythm of the case. I think that it can be very important when and we've seen it in other trials, where they're presenting evidence, and then there's a stopping point. There's a delay for whatever reason, either planned or unplanned. And it gives the jurors time to ruminate about what they've heard, and either in a good way or a bad way, depending on where the stopping point is. It's not as if it could be planned. It sounds like it was something that was unexpected. There's some really interesting sort of facts around this. I mean, California, as you know, is a interesting place when it comes to demographics and locales. And so, I'm in Los Angeles, massive place, right? Like almost 10 million people are in Los Angeles County. Not hard to pick a jury, really. Unless of course you're a Bronco driving down the street, at slow speed. I mean, then it can get a little difficult because everybody's watching.
I have no idea what you're talking about.
I have no idea what you're talking about, but unless you're watching on TV, because, the helicopters and stuff. But these two places, so, San Luis Obispo County, it's about 283,000 people live in that county. And so it's very, very small by comparison, and it would be very difficult to pick a jury in that town. So they moved to Salinas, which is only 437,000 or so people. And so you've got two juries, and you don't want to have to redo this. Because it's just so small. And it was these are really small, tight-knit communities. And so you don't want to have to try to do this again without, given all the publicity around it. I mean, I know I've done stories on this already.
I agree with you. And I think that's maybe part of the reason why the judge is taking a delay rather than seating another juror. Because he knows this is going to be a very long trial, and he doesn't want to lose any jurors. And I know that they've got several alternates. I can't remember right now how many, but you can run through alternates too, especially living in the time of COVID. You can lose alternates. And I'm not talking about people passing away. I'm talking about people just getting sick and they can't delay the trial that long. But the last thing you want as a judge, I know one of the things they fear is somehow getting it to a point in the trial where they run out of jurors and have to declare a mistrial and do this thing all over again. So I wonder if that's why the judge is kind of willing to take these little pauses here and there, because he wants to make sure he saves all of his jurors. What do you think?
I agree. And I think that because of these counties being so small, I mean, can you imagine trying to do that in Los Angeles County? Judges got to move, move,
Yeah.
move. I mean, the things are backing up. So they can take that time and do that there. Whereas here, that's not possible.
Yeah. Yeah. All right, Dr. Pearson, I know you've been following this case closely. We have a cold case, 25 years old. We've got a no body case, never found her, no autopsy could be performed. We've got no eyewitnesses that I've heard of so far, and very little forensic evidence. What is the prosecution going to need to do to bring home a conviction in this case?
I love cold cases, particularly because of the technology aspect of this. She disappeared in 1996. That was the year I started college, or I started my last year of college. And so, just a couple facts. Google was invented that year. There were 44 million people who had cell phones. There was no cell tower in San Luis Obispo. And so you couldn't do the pings. You didn't have the advantage of technology that we have today, like we saw in a recent case. So,
and not to interrupt you, but you got me thinking. I imagine the proliferation of surveillance cameras, not nearly as much as it is now.
No,
you can't walk down the street with 19 cameras catching you now, but back then, who knows if they had any within a few block radius.
Absolutely. I mean, when I first moved to LA, which was a few years ago, 4 years ago, I remember watching people crossing the street using cardboard to try to shield themselves. And I didn't understand that at the time. I now do. So that we didn't have cameras everywhere, and certainly not in that area. And so the way I look at this case is it's a circumstantial evidence case. We don't have a body. So how do we prove she was dead? Well, we have a legal determination of being declared dead. That happened on May 25th, 2002. So there's a judicial decision that she's now deceased. Because there's no direct evidence, we're dealing with circumstantial evidence, which means that it's evidence that when you draw a reasonable inference leads you to a fact. And so the way I think about those cases is that you're trying to build a layer cake, and you use many different kinds of evidence to try to shore up that layer cake and make it dense so that it can't be knocked over. And the defense's job, and that was my job when I did defense work, was to poke holes in those layers to get it to fall like a Jenga puzzle. And here, it's looking, honestly, I look at it and I think it looks pretty good, but for the prosecution, I mean, you've got a person who puts Ms. Smart with Paul Flores, one of the last persons to see her alive, it appears, her friend Cheryl Anderson. They're leaving a party. Ms. Smart goes off with Paul Flores. She is seen as intoxicated that evening, passed out, and can't stand on her own accord. You have a different kind of evidence. So you have forensic evidence where you've got 4 cadaver dogs who have all alerted to the smell of death in Paul Flores's Cal Poly dorm room, and specifically to his mattress. You have folks who have made allegations against this man in the past with respect to him drugging and allegedly sexually assaulting them. So that information apparently is going to come in. And then you have some additional forensics. You have an anthropologist who saw a disturbance in the soil underneath Paul Flores' father's home, underneath a deck. You have fibers that would not normally be seen in nature, certain colors like blue and red and white, which were all consistent with what Ms. Smart was wearing at the time. The depth of this disturbance is about the size of what a casket would be. There's a tenant who says that the plumber was deprived access to this locked area where this disturbance was underneath this deck. And there had been a flood there, and that Mr. Ruben Flores had said, "No, I'll fix it myself, thanks." But there was a neighbor who observed a trailer being backed up to this deck area late at night one night, and that people who normally wouldn't be spending the night, his ex-wife and her new boyfriend, had spent the night that evening. And you have additional information from law enforcement where the behavior of the defendant So Paul Flores he gives some story about why he has a black eye, that he was playing basketball, and they go interview the friends, and the friends are like, that didn't happen. And so now he changes his story. So we have an inconsistent statement, to he bumped his head while he was working on his car. And then he abruptly leaves the interrogation room. And so that gets to guilty mind evidence. No person who was innocent would do that sort of behavior. Right. So I think it looks pretty good, but I don't know. I haven't seen the evidence. I don't know all the evidence, and I know where they're going to poke the holes.
If that was the prosecution's closing argument, you would have convinced me. I thought that was pretty good the way you laid that all out. You talk about building a layer cake. I use a much more graphic example, but I say it's like a death by 1,000 cuts, right? They're not gonna get this with one home run kind of piece of evidence, but it's all these tiny pieces of evidence, and you continue to add them up and pile them together, and that's where you get beyond a reasonable doubt. A very good friend of mine from the prosecutor's office, his name's John Lewin, is a prosecutor here in LA who specializes in cold cases. And one of the ways he describes it, he deals with a lot of cases that are, very old and oftentimes no body. And what he talks about is sometimes it's not so much of a who did it as much as it's no one else could have done it but this person sitting here in court. And I think that's what's going to happen in this case is he's the last one with her, as you point out. He's the only one that's got the cadaver dogs signaling to his room. His dad's the only one who's got a coffin-shaped hole in his backyard. I mean, you start putting it all together and you go, oh, okay, no one else could have done this. And I think they might be able to put this together. I do. My other thought is this. 25 years is a long time to keep your mouth shut. And I think that the Floreses probably talked to someone in that 25-year period. And I think that someone finally got a conscience and came forward. And my prediction, we'll see if I'm right or wrong here, is that someone is going to testify that somebody said something about knowing where that girl ended up or how she died or where that body not ultimately is, because I think they would have found it, but where it had been at one point. So we'll see, but it's a fascinating case from a lawyer's perspective to see how they're going to put this all together. And we'll continue to watch it closely. We're going to do something a little bit different now. We're going to take a look at some cases that are making news around the country. And we'll talk about them briefly. And I just kind of want to get your hot take on some of these. So the last two of the 4 Minneapolis police officers indicted by a grand jury were sentenced this week for violating George Floyd's civil rights. Derek Chauvin pled guilty in December to using excessive force after pressing his knee to Floyd's neck for 9.5 minutes. In February, jurors convicted Alexander King alongside Tuo Tao and Thomas Lane of violating Floyd's rights by denying him medical care. King was sentenced to 3 years and Tao to 3.5 years in prison, and Lane was sentenced earlier to 2.5 years. Do these sentences surprise you? Too long, too short? What do you think?
I think they're too short.
Really?
And that is federal sentencing guidelines aside. Okay, we know we've got the little rubric and the whole thing. Look, you're a police officer. You're seeing something happen that's wrong, right? You should know what's wrong, and you should be able to stop them. And when I listened to what the judge said, which was, it was his second day on the job, and right. He didn't know any better, and the training was bad, defense argued. No, you're a police officer. You should know what something wrong is. And if this person weren't a police officer who was doing it, boy, you would stop them, wouldn't you? Yeah. You would do something. And so that badge meant something in that moment, and that needs to be punished.
Yeah. You think it's going to have a chilling effect on law enforcement? You think other officers are watching this? And part of their defense, as you pointed out, and the judge highlighted, they were following some orders, right? There's a chain of command in law enforcement, and there should be. And Derek Chauvin was the lead officer or the most senior there, and he's telling them everything's fine, don't move. And they're following orders, right? You think that other officers around the country are watching this and going, now I don't know which way is up.
Absolutely. I've actually talked to law enforcement colleagues and friends, and they feel that they can't do their jobs anymore. But chain of command is part of the problem. I mean, airline industry followed chain of command until they didn't anymore because there were problems that occurred and people had information or new information or should have challenged the captain and didn't. And so I think that what we need to do is see a rethinking of that. Because, when you have chain of command, it also has to go in concert with responsibility for the conduct. You have chain of command and responsibility for making the leadership decision. And historically, we haven't seen that happen until this case. And it seems as if, Chauvin is paying the highest price, which he should. But the others participated in that. There were people that held the man down and helped restrain him, but they're going to get off with a few years. That just makes no sense. And then the guy who's holding back the bystanders, including the colleague, the former or not former, but the ambulance, paramedic who's off duty, who's like, I know that he's dying or is dead. Get me in there, and wouldn't let her in there.
No. Yeah, I don't know. It's a totally tragic story, and I understand holding them responsible. I also know people in law enforcement, and they're scratching their heads going, you're trying to control the crowd. It's a fluid situation. You've got people yelling at you. You're trying to do your best. But I agree with you that there has to be something done to kind of rethink how some of this is done to avoid a tragedy like this again. Now we're going to jump all the way across to the other side of the world to Moscow. WNBA star Brittney Griner has been detained in Russia since February after vape cartridges containing cannabis were found in her luggage. In a shocking development, the State Department announced that it had offered a prisoner swap of Griner along with former Marine Paul Whelan in exchange for the release of Victor Bout, an arms dealer known as the Merchant of Death. The Russians have been clear in saying, however, that no agreements have been finalized. What are your thoughts on this, Dr. Pearson?
It wasn't until I really looked into the story that I developed a wholly different opinion. And I don't think that we should be trying to get Paul Whelan home. First of all, he was born in Canada. His U.S. Citizenship is by naturalization. His parents were British and they have Irish ancestry. So he's American by naturalization. He's Canadian by birth. He's also British by through his parents and Irish. And he's got this fascination with genealogy. But this is a guy who had a dishonorable or a misconduct. I'll say misconduct discharge from the Marine Corps. For larceny. He bragged about knowing an FSB agent prior to going to Russia, showed up with $80,000 in cash on himself, going to a wedding. And the most important thing is that the person they'd be exchanging for is a person who the U.S. Arrested and convicted. It was through a sting by the DEA as part of what they would call a narco-terrorist organization. That this guy was going to be selling a massive quantity of weaponry to this organization. And so, I'm sure it'd be really helpful to get the guy who knows how to get the weapons, the missiles, the all the things that Russia might need to help continue to attack Ukraine home. And so I just think that it's probably a bad idea for a lot of reasons. And I respect Brittney Griner wanting to get home and also standing up and saying, I'm not going without Whelan. But I'm not so sure she knows everything there is to know about Whelan. And, it's not time to pull the McCain here on this because you need to get home. Yeah. And what they're doing to you is unfair. It's utterly ridiculous the way that they've approached this.
Yeah. I appreciate all your points. My thought was, she started to get so much media attention and there's constant kind of talk and chatter about her. And then it started to leak into the celebrity world. And then you have people like LeBron James making comments about her, and the Russians are not stupid. And I think they realize who they've got and how valuable she may be from a PR perspective to the United States. And now, like you said, they're asking for the Merchant of Death in exchange. They're playing 3D chess here. Is my thought I wonder if things would have turned out differently if people, especially celebrity types, had not been commenting on it so much. including, I thought it was an interesting move, and I'm curious to hear your thoughts, that the State Department announced this offer before it's even really accepted by the Russians.
Yes, I don't know why that happened. I can't explain that. But at the very beginning of this, there hadn't been a lot of media attention on it. It was sort of a blip. And there was some discussion early on about don't talk about it. Don't make this a thing, a public thing, because of that very reason. It would in essence escalate Brittney Griner's value or increase it. And then Russia would be in a better bargaining position, because this is what often happens. They arrest one of our people and then we do an exchange. And this is sort of it's a stupid fact pattern, in my view, that there's this, she gets nicked for a couple of vape cartridges purportedly in her luggage, and they call it drug trafficking. And that has to do with the average dose that Russia assigns to that sort of drug, and that she was using like 468 times, or she had 468 times the average dose on her, because it's like 0.0002 grams or something is what you would inhale. So it's one of these technical things that they then blew up to make an opportunity to try to, I think, get someone back.
Yeah. Wow. Well, let's see what happens, right? I mean, we may be finding out any day now if she's coming home or not. Okay, our last kind of couple of cases for the day is a couple of really interesting cases involving parents suing social media platforms. First, there's two parents, or a set of parents have sued TikTok over after the blackout challenge, as it's called, leads to the death of two young girls. The parents of two girls who died after allegedly attempting this challenge popularized on the app are now suing the social media company TikTok. Lalani Walton, 8 of Temple, Texas, and Ariana Arroyo, 9 of Milwaukee, died last year, allegedly after attempting the challenge, which encouraged users to choke themselves until they passed out. Both victims accidentally hung themselves. This is just so tragic and awful and stupid and avoidable to me. But the complaint alleges that the company did not do enough to warn parents of the dangerous content being propagated by TikTok's algorithm. TikTok contends that they remain vigilant in user safety and that many of these quote unquote challenges originate outside of the app. Okay. Keeping that case in mind, there's a similar lawsuit of parents who are alleging that Instagram fueled their daughter's eating disorder and depression. Jennifer and Benjamin Martin of Kentucky allege that Instagram created the perfect storm of addiction for their now 19-year-old daughter, Alexandra Martin. The lawsuits filed against Meta, the parent company of both Facebook and Instagram, allege the company needs to be held responsible for, and this is a quote from the lawsuit, causing and contributing to burgeoning mental health crisis perpetrated upon the children and teenagers of the United States. Specifically, the lawsuit alleges that Alexandra was repeatedly bombarded and exposed to content recommended and or made available to her by Meta, which increasingly included underweight models, unhealthy eating, and eating disorder content. All right, Dr. Pearson, I'll let you jump right in. What are your thoughts on these lawsuits? Are they on sound footing?
No, they're not. I don't think that the Instagram, or rather, the Instagram Meta one is on sound footing at all. If that were the case, then if I had known this, I would have filed lawsuits against Vogue and Cosmopolitan and all sorts of magazines when I was a kid, because those were the people who were sending me the messages that were being picked up and then being, reinforced amongst my peers. Yeah. So there's that. There's a causation problem.
Right. You're making me think of it, but again, I'm not trying to belittle eating disorders, and I know we have an epidemic of that we're dealing with in this country. But I was thinking, when I was a kid, there was Barbie dolls for girls and He-Man for boys. Neither one of them gave you a body image that was entirely attainable. But sorry to interrupt. I'll let you continue.
No, absolutely. I mean, I don't think Barbie's measurements have changed since back then either. So there's still opportunity, folks, assuming this goes through. Right. But the TikTok one is a concerning one, because it sort of it triggers for me, and I don't mean to use that word, but it triggers for me the Cruz case, which is that if you have somebody who's out on, who's making sort of these, if you will, violent, sort of terrible, dangerous sort of comments or putting this stuff out there, you ought to have somebody on your network who is making sure that that stuff isn't there. But simultaneously, you also have to have parents who are supervising and that you know what your kid is doing at all times. And so I think there may be, I don't want to say contributory negligence there. I don't want to say that at all, because obviously these people suffered immensely. But I just think that TikTok bears a little bit more responsibility here, because it was on their network. It was clearly a problem, as opposed to something like a visual image of somebody making someone feel like they need to look that way. That was just different to me.
Yeah, that it's an interesting distinction that you make, and may end up being the same one that the judges in those cases make. I do know that we are suffering from this kind of mental health crisis amongst young people. I do not think these social media platforms are helping at all. I think they probably are hurting, but I wonder if these types of lawsuits are the way to solve it. And I wonder then what the actual platforms themselves can do to solve it. And those are a bunch of questions that I don't know if either one of us could answer. But that is our show for this week. So Tracy, thank you so much for coming on. Where can people find out more about you?
Oh, gosh. Well, they can check out my website, tracyexplains.com. They can follow me on Twitter, Tracy Explains, and on Instagram, same thing, Tracy Explains. And they can see me definitely on Law and Crime Trial Network every Tuesday, but I'm often on multiple days a week, and they can see me on other networks as well.
Fantastic. And I'm your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ, or check out my website, joshuaritter.com, to see what I've been up to, or if you're just looking for a lawyer. And you can find our Sidebar episodes wherever you get your podcasts. And we want to hear from you. If you've got questions or concerns you'd like us to address, tweet us your question with the hashtag TCD Sidebar. And thank you for joining us at the True Crime Daily Sidebar.